What if you told someone, if I don't hear back from you, I'll assume we have a deal? Sounds convenient, but in contract law, it's a recipe for disaster. In 1862, an uncle and nephew learned this the hard way in Felthouse versus Bindley, a case that shaped one of the clearest rules in contract law, which is silence does not mean acceptance. Background story. Paul Felthouse, a horse dealer, wanted to buy a horse from his nephew. They had discussed the sale, but the price was unsettled. Felthouse then wrote to his nephew saying, "If I hear no more about him, I consider the horse mine at £30.15. The nephew intended to sell the horse to his uncle, but he never directly replied to confirm. Meanwhile, the nephew's farm stock was being auctioned by Bindley, the auctioneer. By mistake, Bindley sold the horse to someone else. Felthouse sued Bindley for conversion or wrongful sale, claiming ownership of the horse. The question was, had there been a valid contract between Felthouse and his nephew before the auction? Issue: did the nephew's silence amount to acceptance of the uncle's offer, thereby creating a binding contract? Rule: the court reaffirmed the principle: silence cannot constitute acceptance. Acceptance must be communicated clearly to the offerer. Application: the nephew never sent any message agreeing to the sale price. His intention wasn't enough without communication. Even though he told others he wanted to sell to his uncle, he didn't tell his uncle directly. Without communicated acceptance, there was no binding agreement. If there's no contract, Felthouse had no ownership rights and thus couldn't sue Bindley for selling the horse. Conclusion: the court held there was no contract. Silence, even with intent to accept, is not acceptance in law. The Felthouse versus Bindley case is a timeless reminder that in contract law, a deal isn't done until acceptance is communicated. You can't trap someone into a contract by saying, "If I don't hear from you, I'll assume you agree." From 19th century horse trades to modern email negotiations, the lesson still holds: speak up, or there's no deal. If you enjoyed learning why silence isn't acceptance, smash that like button. Subscribe for more case law stories, and comment the next case you want explained. Let's keep making legal history easy to understand.